The Senzo Meyiwa murder trial is continuing today in the High Court sitting in Pretoria. Investigator Sergeant Vusumuzi Mokhane continued with his testimony. In fact, he was cross-examined today. Mokhane traced and arrested the suspects in the case. We're now joined by Mpumelelo Zikalala, a legal analyst, to speak to us about some of the salient points we heard come out of the cross-examination. Thank you very much for your time this afternoon. It was Advocate Mngomezulu on behalf of accused number 1 and 2 who was speaking about the importance of an accused appearing in court within 48 hours. So accused number 2 on the 19th of June 2020 made a confession without being charged. He put it to the witness, and if that confession was at a police station, he said, there would be an entry, but there is no entry because that confession was made in an open area, and that is why he argues that there is no entry, which gives credence to their argument, at least, that their clients were coerced to make a statement. And so on the reasons why a person needs to appear in court within 48 hours, what do we need to understand?
Good afternoon to you and also to your viewers. Well, it's compliance with Section 35 of our Constitution. It's very clear, as it says, everyone who's arrested then must appear in court so that their rights can be explained to them. It's all about the protection of the individual who's being arrested. To say, if you know the clarification of what is about to happen, then you must be able to have access to someone with better understanding of the legal prescripts that are there, which is a legal practitioner. And it rests upon the shoulders of the presiding officer to then say, as soon as a person appears in front of you, you must read those facts to them. They must be able to understand them. Now, to add upon the particular intention which has been made by the law, if you look at Section 217 of the Criminal Procedure Act, dealing precisely with admissions, the Act is very prescriptive. It says any admissions which are made also must then be confirmed in front of the magistrate, so that the magistrate can then lament this particular factor and lament these a reminder to the accused individual to say, you have these rights, by the way, to a legal practitioner, someone who has a better understanding as to what you're actually confessing to. I think this is what the defense is trying to say in this case, to say, well, this is what we've been saying all along. The reading of this particular right was simply a tick box exercise. They did not do it because they wanted the accused to understand, and whatever confessions that we may have gotten on that particular day are not confessions that must be accepted by the court.
Now, arguments must be prepared within this trial, within a trial, on this particular matter. Is there something that is unusual? It would seem there is no consensus amongst the authorities in court.
No, not at all, but I think it's something that you would have had to do at the end of the trial. But I think the judge is saying in this case, no, I want to deal with all the factors and all the elements of this trial within a trial at this stage, and be able to be done with it. It is a point in which you have 3 legal minds or 3 legal views that are there, and one will have to emerge. And in order for that to happen, the individuals that are involved have to come back and present credible cases as to why those particular admissions have to be. But it baffles my mind as to how it would happen that a person is then taken by the police without being arrested or detained. It has to be one of the two. Unless the person walks into the police station and says, I've committed this particular crime, even then, some sort of arrest action or positive action is required from the police. And the minute you say that a person has been arrested, you have deprived them of their freedom. You will have to follow the prescriptions as it is lamented in Section 35 of our Constitution. You have to follow the prescripts of the Criminal Procedure Act. Otherwise, whatever in which you are obtaining within those particular period cannot be taken by the court to be something that is acceptable, cannot be taken by the court to be a confession that can be utilized. So I think the court is plain safe, saying, I want to be able to rule when I've received all the submissions. I want to open the doors to everyone, make your submissions so that when I'm ruling on this matter, no one is going to complain.
Okay, let's revisit this moment because the witness, Sergeant Mokhane, has some homework. He has to bring dockets to the court. Let's revisit that moment.
Sergeant Mokhane came to testify in relation to case number 163.
Yeah.
He never furnished sufficient information. He had no docket when he arrested accused number 2, and he did not bring the same docket in court when the proceedings started. And I would request that the witness bring the docket so that we confirm all the contents of the docket and what was the charge preferred against those accused or against the person reflecting under case 163 of 10/2018. When can you bring that docket, Mr.? Can you also furnish further dockets that relates to Ndanzi, especially the drug case and the possession of unlicensed ammunition? Thank you, Malota. With your indulgence, Malota, request this part of evidence to be stood down.
Mpumelelo Zikalala, what do we need to understand about that moment? It seems to be plenty here.
I think the state should have prepared a bit better when it comes to this particular matter. And remember, it's a state that is the burden of proof. So if anything is going to be disputed and not going to come back with a rebuttal, then the court has no option rather than to exclude that piece of evidence, because it cannot be taken to be the only truth and only version that can be understood. So it was supposed to be the state to say, if you are coming as a witness, this particular individual has been arrested a number of times, so we need to understand whether each particular arrest was perfected up until the end. Then just come with those particular dockets so that we have the case name or the case number, we have the case in the sequence in which the person then appeared, if they were appeared, the reading of the rights, because it is something which is in contention as we speak now. So what the defense was trying to do was to say, the waters have been muddied a bit, so you want to be accurate in terms of saying, what was the accused arrested for? Did you follow the correct procedures in each of those particular arrests? And let's look at the one which is the bone of contention now. If the procedures are not followed to the T, the law is very clear. All the evidence that may have been collected cannot be regarded by this particular court, and it has to be something that is going to be ignored. So I think that's what they're trying to do by saying, call this evidence. Well, we want to read it into the record so that we're able to prove that our clients are innocent.
Okay. And then there was this moment in terms of accused number 2 being fed as he was detained, because there was a 3-hour period that was not accounted for, and in the time, he was booked out, and in the time that he was booked out throughout the day, it was put to the witness whether they actually fed him, and this is how it went.
Since accused number 2 was booked out, besides the bookings in and out of the 17th and the 16th, particularly the book out from 8 o'clock up to 2:30 in the morning, did he eat anything?
8:05 Hussein got 18 official Hussein fast 2. Did it have Chawagano? No, we are not cruel policemen. Whatever we had as food, we shared with him. And whatever we drank with him. He mustn't paint us as bad policemen. We also asked him which brand he preferred, and we would make his choice and would buy it for him so that we could eat.
These are not unreasonable police officers. How helpful is this moment? Or rather, not even helpful, but what do we need to understand that as ordinary South Africans, should you be incarcerated, you have a right to be fed?
You have a right to humane treatment, which is why it's assessed by SAPS officials to go back to what the book says. So if a person has been arrested, take them to the police cells, make sure that they're able to come to court within the 48 hours. Criminal Procedure Act allows for 7 days for the investigation, and you can book them out within that particular period, but make sure that they're able to be fed. Because I think what the defense is driving to in this case is to say, look at the inhumane manner in which our client was being handled in. Food deprivation was there. This person was made to suffer. So coercion may have been part of the things that have been stated to him to say, if you want to eat this particular food, then you must make this particular confession. Secondly, let's look at the state of mind when the person is making that confession. If you haven't eaten for quite a while, are you able to function in a proper manner? Are you able to think in a proper manner? But most importantly, are you able to understand the things which are going to be stated to you, which is what they've been driving it all this time, in terms of saying, yes, the rights may have been read to him. Yes, they may have been asked to check in this particular box or to sign. But the most important thing is, Did he understand what he was agreeing to? Did he understand the gravity of saying yes and the consequences which are then to follow? So if you are trying to paint a picture of a person who is put in a position where his back is against the wall, deprived of food, and also goes very scared, meanwhile there's been non-compliance with the applicable legislation, then definitely that particular piece of confession cannot be admitted. Just remember why this particular admission is important for the state. It sort of seals the deal because it doesn't need to prove beyond reasonable doubt on any other things, because once the confession has been admitted, then it means that it's much, much easier for us to prove our verdict. For the defense, it is crucial because once the state wins in this particular trial within a trial, then it's a lot harder for them in order to state the innocence of their client. However, if they are able to poke those holes, then an acquittal is along the horizon.
How long can a trial within a trial go on for? Because if you're not paying attention, it's easy to get lost, because we've had a number of witnesses in this trial within a trial on its own. Because then how do you also determine which way this is going to go? Is there something that you see that tells that perhaps indeed, at the end of the trial, within the trial, then these confession statements will be admitted as evidence or not? How do we check in on how we are faring?
First, we have to look at the number of witnesses which are going to be there. It's within the chain. Who are the individuals that were involved in this matter? So the magistrate, the police individuals that were there, any other person that may have touched even any confession statements that have been there. So if they're able to prove and be able to testify to the right stage or the stage of mind of the accused, then you can bring them to the court and say, I want to bring you as witnesses within a trial. At the end of the day, the court has a discretion. They can say, we are going to make a determination of whether this confession is admitted or not at the end of the trial. Make submission now, because I want to piece in these puzzles all together. I don't want to deal within a piecemeal approach. There may be evidence at the end which may come in, which may rebut everything that is there, especially the evidence of the accused in this case. So I'm not going to simply rule on it as in now, but I'm going to say at the end of the trial, at the end of the court, it's only then in which this particular evidence is going to come in. But as to the extent of how the trial within a trial has to go on for, it purely depends on the number of witnesses that are there and how fast can you bring in those witnesses through examination in chief, cross-examination and re-examination.
So we're likely to hear from the likes of Brigadier Geninda, because his name has been bandied about quite a bit.
Definitely. If there's something that has to be further explained by him, then definitely that particular individual must come in. Another person would be interested to hear whether he's there or not and can be able to give evidence to be subpoenaed is the alleged liquor rep of accused number 2. So if that particular person is there and they can say, yes, I was there, I was representing this client on a number of matters, yes, their rights have been made, I think that partly seals the case for the state in terms of him understanding as to whether he purely understood what he was doing at that particular point in time. Of course, there are differences, because accused number 2 can come back and say, even there was a language barrier, I do not know, I did not give this person any instructions to represent me. So it is one of those in which up until all the individuals which are involved in this particular chain are going to come and testify, we can still continue within a trial maybe for the next 2 weeks.
Thank you very much for your contribution this afternoon. Mpumelelo Zikalala is a legal analyst.